My name is Brenna. I'm from StepStones for Youth, Program Director at StepStones for Youth. And our peer-to-peer knowledge exchange is in collaboration with OECAS. Um, I'm not sure if, Sonia, do you want to get us started for introduction?
Sure. Yeah, I'm Sonia Sprazza, the Youth Services Analyst at OECAS. And do we want to do quick finish introductions or can I share a little bit of the background?
I think we'll share and then we'll go over when the presentation starts.
Brilliant. So I just would like to share that the peer-to-peer knowledge exchange is a monthly cross-sectoral collaboration and skill sharing hub. It's coordinated by StepStones for Youth and the Ontario Association of Children's Aid Societies. All of our attendees are stakeholders from across sectors with a shared commitment to supporting the well-being of children and youth in and from the Ontario child welfare system. Every month, StepStones for Youth and OACAS co-host this virtual webinar featuring organizations, initiatives, and individuals who are sharing best practices, gives a chance for everyone to ask questions and also learn from each other. The P2PK was the vision of our founder, Shua Roskies, who at the time was at the Office of the Children's Lawyer. And she was doing this in response to gaps in services and supports during the COVID-19 pandemic. She really sought to create a space where child welfare practitioners and child and youth and family service organizations and youth in infirm care could come together to share best practice and amplify innovative programs and strategies to support children and youth. And we're really pleased to be able to continue to offer this in her memory.
Thank you. So today we have a presentation presented in partnership with Never Too Late and Downtown Legal Services. So we have Philippa from Downtown Legal Services and Charlene from Never Too Late. Together, they will explore why family status continues to have legal importance into adulthood, including how it impacts areas like substitute decision making, inheritance, and other rights. This session will also cover how legal family relationships are affected for youth involved in child welfare and what connections remain after aging out of care. Folks will leave with practical tools to help ensure that trusted individuals, such as friends, can have legal recognition and decision-making authority when needed. As always, we're going to wrap up around 2 p.m. We'll leave some time at the end to open the floor for questions. And we're going to be monitoring the chat throughout for any technical issues or any ongoing questions. And just a reminder, the presentation is being recorded, and we're going to be following up via email with resources and the slide deck. So with that, I will pass it over to Philippa.
Thank you so much, Brenna. So as Sonia let you know, I am a lawyer with Downtown Legal Services. We offer services around income security, health, disability. I formerly was a lawyer at the Children's Lawyer, where Shua and I worked together, and I've also been a lawyer with the Public Guardian and Trustee and in private practice. So now I practice poverty-related law and teach a number of law students at the University of Toronto. And then Charlene was just going to let you know about herself.
Thank you very much. So I am a lived expert myself, and now I am the Never Too Late Lived Expert Coordinator, and I focus on building relationships and community with lived experts. For Never Too Late, a young person whose child welfare services are terminated, also known as aging out, does so without the one thing they were promised when they entered: people to support them through life who are not paid to be there, humans in Never Too Late language. Never Too Late was co-founded in 2018 by people who believe everyone has a right to permanency. We are a community of people who believe that everyone has the right to belong with people who love and value them unconditionally throughout their life and are not paid to be there. We work to recruit, connect, educate, and train, support, and advocate to give back to living experts of child welfare systems the chance to have family to rely on no matter their age. Our focus is on community development, and our values are community, accountability, belonging, and safety. We want to thank you for being here to help us unpack the family backpack.
Thanks so much, Charlene. And thank you again to all of you to hear us blarp on about not just anything but law, gross, but it does end up mattering to people. And we do want to let you know what kind of help there is available and how you can maybe avoid some of the entanglements that that otherwise might arise for you and for your clients. We're all familiar with the multiple intersecting sources of vulnerability that arise from someone whose child welfare services have been terminated. Vulnerability in the areas of housing, of finance, in social circles. But there is another layer atop this terrible lasagna, and that is that the legal situation of people who have aged out of foster care is complicated because the law cares a lot about family status. And when I say family status, I mean that in a really narrow way, not as is so crucial and as Never Too Late concentrates on the network of supportive and chosen relationships that a person maintains for themselves, but the people who are legally defined as being part of that person's family. The law often uses family status in order to hand out rights and benefits and entitlements. And that's true for people of all ages, not just for children. That's what we describe as the family backpack, the package of legal rights and powers that comes along with legally being defined as a member of a certain family. And that's what we're going to unpack a little bit today. First, the annoying bucktooth lawyer wants to give a small caution, which is, as you know, this presentation is being recorded. It will be shared with members of the public. We hope to have some interesting questions later on, but we ask you not to share any names or any identifying information for anyone, any person to whom you are providing services. We're thrilled to hear your questions and to provide information in response, but this is not the setting for us to provide specific legal advice about specific cases. We can always connect later if that's what you're looking for. So I want to begin with a scenario, and this is not a scenario for any particular case, but it does contain a number of elements that are familiar to me that I've encountered in my work, and maybe that you've encountered in your work too. So let's say that we have a young person in Ontario who was taken into the care of a Children's Aid Society when they were 14. And they have a diagnosis, say, of developmental delay connected with fetal alcohol spectrum disorder, as well as PTSD. They haven't seen their birth mother, their original mother, since they were removed by Children's Aid, and they have not seen their original father since age 2. They have an older sibling who was not taken into care, and after they turn 18, they continue to live with their former foster parents. They have never been legally adopted. Chances are there's a relationship there, but legally speaking, they have not been adopted. When they are age 21, something happens. Things have a way of happening. They fall down the stairs, they sustain a head injury. And because they have pre-existing FASD, their symptoms are more complicated. Their recovery is going to end up being more complicated. So their care team reaches a conclusion that, at least for the time being, they're not able to direct their own care, that someone else is going to need to be brought in to decisions about maybe surgeries, maybe discharge planning, maybe a course of rehabilitative treatment. So the question is, there are various ways in the law that you could plan to have a decision maker appointed, that you could plan for who will make decisions in a case like this. For example, someone could choose to make a power of attorney, appointing who they want to make treatment decisions for them if it ever becomes necessary. But let's say that nothing like that has happened. It's an emergency. Someone needs to make decisions right away. Someone will need to make decisions for the foreseeable future. Who, by default, will have the power to do that in Ontario? So will it be a government official, this young person's original mother, their original father, their original father's second cousin, their older sibling, or their former foster parents? If anyone wants to comment in the chat, either if they think that if they're certain which one of these it is, then you could indicate that. Or if you're certain that there's one of these that it would not be, then you could go ahead and indicate that. Or if you're totally unsure which of them it would be, then that's available too. So we have someone saying parents. Is there general consensus that it would be parents, or not foster, original mother and father, not foster parents? Yeah. Any other thoughts? Is there any possibility that it could be someone other than the original parents? All right. So by default, it could be any of these except the former foster parents. So any of these people, government official, original mother, father, original father, second cousin, or older sibling, potentially could, by default, end up being the one with the legal authority to make medical decisions. It could not be the former foster parents unless special arrangements were made in one way or another for them to be appointed to have that authority. Why? Emergencies happen, this we know, and the law often has to plan for emergencies to happen in one way or the other. When it comes to things like consent to a health treatment, the law has to make sure that there's always someone in place who can consent to medical treatment if someone isn't able to do it for themselves. Otherwise, you have a gap. And so we have this law, the Healthcare Consent Act, that's designed to make sure that there is always someone who is legally authorized to make treatment decisions if necessary. And how it does this is that it sets out a list of people who might be able to make that decision. And that list of people is prioritized. They're in a certain order. So the hospital, if they're looking for someone to make a treatment decision, is going to look for the highest person on that list who is available and willing to make the decision. Most people on that list are family members of different kinds. Then, at the very bottom of the list, if no one else is available, then the decision would go to the public guardian and trustee, a government office, which is a division of the Ministry of the Attorney General. So this is the actual priority list. At the top, we have a number of people who have been specially appointed to make decisions. So a guardian of personal care appointed by a court, an attorney for personal care, who is a decision maker appointed in a power of attorney that would be executed by the person who may need decisions to be made for them. And then there's a form of decision maker who can be appointed by the Consent and Capacity Board to make limited powers. So any of those decision makers have precedence over family decision makers, but it takes some planning and some work to have them appointed. Under that, you have family members, and they can make decisions without any form of appointment whatsoever if they are the highest ranked decision maker on the list. So spouse or partner comes first, then a parent or an adult child, a brother or sister, and then there's a big one, any other relative at all, before the public guardian and trustee. One of the weird and badly planned things about the Healthcare Consent Act is that while there is an ability to appoint a decision maker of your choice by making a power of attorney for personal care, there is no ability to say, I don't want person X making decisions for me, ever, at all. There's no way to just knock someone off the list completely. We hear someone saying, how is relative defined? like most laws, it defines a relative as a relative by blood or adoption. So in the list of examples, I gave the possibility of the father's second cousin. That's a relative. That's a relative under the Healthcare Consent Act. It's a distant relative, but if there's no one else who's higher ranked on the priority list, if the hospital can't reach someone who's higher up, that second cousin could be the person who is authorized under the law to make decisions in preference to a government office. The question of who actually will be authorized to make the decisions, who will actually be the one to do it, depends on who the hospital can find and who will pick up the phone and agree to make the decisions on a particular day. That's what determines whether it would end up being original mother, original father, sibling, or some other member of the family. Healthcare Consent Act only deals with treatment decisions. It doesn't apply to every category of personal care decision that might need to be made. But there are a lot of things that come under the heading of healthcare. It includes admission to a long-term care home. Not something that a young person should ever have to be thinking about, but we all know that the picture when it comes to housing for people who have high needs arising from disability is very, very dire these days. And people with high care needs are being are sometimes being admitted to long-term care homes because there's no other place for them to live. I see someone saying, does it apply to a MAID decision? And it does not, because at this point in time, substitute decision makers of any kind are not allowed to make decisions about medical assistance in dying. The question has been raised whether the law should be changed to allow that to happen, but at this point, it does not. So it does not apply to assistance about medical assistance in dying, but it would enable a person to be involved in discharge planning. If a person has a care team meeting about where they're going to go from hospital, what their life is going to look like after discharge, it may involve participation in that. It may involve deciding on personal assistance services, and it may govern access to health information. Because a person who is authorized to make treatment decisions for someone is also going to be authorized to access their health records, with or without the person's consent, so long as they have been determined to be not capable of doing that for themselves, either temporarily or permanently. But people often say, when I get to this point of the discussion, but the young person was removed by Children's Aid. They were in the long-term care of Children's Aid. There was a decision that their original parents should not be making choices for them. And this gets especially pointed in the case of people who have high care needs arising from disability. And we know that young people with disabilities are overrepresented in the child protection system. So someone might have been taken into the care of Children's Aid on the basis that they were not taking appropriate medical care of them and their medical needs. But then 4 years in the future, a person's child welfare services have terminated, and now the original parents again have the authority. Well, here's the thing. The young person was removed by Children's Aid, but in this example, they were not adopted. And again, when I say adopted, I mean the legal technical definition of adoption, going to court and having an adoption order made. I don't mean adoption in a moral sense or in an ethical sense or in the sense of becoming a functional part of another person's family, but in the sense of there being a court order. It is an adoption court order that has the effect of changing the family status of someone, of saying, legally speaking, you're no longer a member of this family, you're a member of this family. And your original parents are no longer defined as your parents, your original siblings are no longer defined as your siblings, etc., etc. A order removing someone into the care of Children's Aid does not have that effect. It takes them out of their family, but it does not redefine who their family is. So it doesn't happen when a person is removed, this severance. It doesn't happen when a person is placed in long-term society care, and it doesn't happen when a person, doesn't happen when a person turns 18. What all of that does, it means that that Children's Aid is going to make the decisions while the person is still a child and while the person is still in their care. But then when the person turns 18, the role of Children's Aid has ended so far as decision making goes. So Children's Aid is not blocking the original parents from exercising the powers and the rights that a family member can exercise under the law. In short, legally speaking, this young person continues to be a member of their original family. For some people, that might be a very positive thing. For some people, it might be completely devastating. But regardless, it is true. And this has legal effects that many people don't think of unless something happens that causes their legal family status to become relevant. Now, some people learning of this might be quite distressed. They might think this is not an outcome that I'm remotely okay with. I want to ensure that someone of my choice is going to be there to make either medical decisions for me or property decisions for me if it ever becomes necessary. And they may have in mind that they do not want a member of their original family to be making treatment decisions for them or medical decisions for them. Or they may be thinking that they do not want a government office to be able to make treatment decisions for them or other decisions for them under any circumstances. So the quick answer to that is that you can plan for that. And by executing a power of attorney, either a power of attorney for personal care or a power of attorney for property or both, you can ensure that you have appointed someone who will have the powers of a decision maker over you if it does become necessary for any reason. For some people, this is a really, really remote possibility, but for other people, it's not really a remote possibility at all. As I said, we know that people with disabilities are overrepresented in the child protection system. And with some people as opposed to others, as they come up to the age 18, it might be more foreseeable that there's a possibility that they will need assistance with decision making in the future. One of the important features of a power of attorney is that the person whom you appoint can be anyone. It can be a trusted friend, it can be a foster parent, but it is one of the tools that are available to make sure that if you ever need those supports, you're not thrown onto the default options under the law. You're able to ensure that the people of your choice, the people whom you trust to be there for you, will have the legal recognition that they need to assist you. So in short, family status matters, even for adults, and many, many laws. We've just been talking about the Healthcare Consent Act, but there are many others, from the Succession Law Reform Act, the Family Law Act, the Insurance Act. many laws use family status to allocate rights and privileges. And typically, they define a family member as a relative by blood or adoption, or sometimes by marriage. Some laws do consider a relative, a brother-in-law or a father-in-law to be a relative for certain purposes. And then there are also some narrow situations in which other kinds of connections are deemed to be family members for certain limited purposes. So, for example, some step-parents may have to pay child support if they have treated someone as a member of their family. Not all step-parents, and that doesn't mean that a step-parent is a relative for all purposes, but for that limited purpose, they're considered a relative. Indigenous customary caregivers. We know that in Indigenous cultures, people might be adopted in a way that conventionally our law has not recognized. And the law is trying to work its way towards recognizing more of those Indigenous customary care arrangements for more purposes. So those are limited ad hoc exceptions, but in general, it's blood relatives and adoptive relatives who can count on being treated as relatives under the law. And removal by Children's Aid does not change a person's status as a member of their original family. So it doesn't change who it is who is counted as a family member for the purpose of those rights and benefits. So let us look into this a little bit and consider what kinds of benefits actually fall out. So we have the right to child support. Who cares? We're talking about young adults. They're not children anymore. The right to child support does not end when a person turns 18. Not when a person is still in full-time education and they didn't choose to remove themselves from their family. And in fact, we all know that it's taking longer and longer for people to become self-supporting. And that is something that family lawyers, family judges rather, have recognized. It's more and more common for parents to be required to pay child support to a young person in full-time education until they've finished at least one degree, because until then, they are not self-supporting. The right to child support continues to be highly relevant into a person's young adulthood. Inheritance rights, this one is big, but can't a person make a will leaving their money to whoever they want? Well, yes, they can. But if a person doesn't make a will, then their money, their property, any kind of death benefits that they might be entitled to will go to family members, legal family members, if there are any. Also, even if a person does have a will, legal family members may be able to claim certain parts of a person's estate, depending on a person's circumstances, but legal family membership creates that right. Citizenship rights. It's very common, of course, for us to be born in Canada, but have citizenship to one or more other countries, depending on where our parents are born. And in those cases, citizenship rights come down through parents. They can be lost if we become members of other families, such that our parents who were born in those countries are no longer considered to be members of our families, or they can be acquired if we are adopted into other families. And what I did not explicitly write here, but which is also the case, is status as an Indigenous person or membership in an Indigenous band can be something that is associated with family status. The right to access personal information held by the government. I've phrased this very vaguely, But there are many situations in which someone who is a legally recognized family member may be able to get certain information from a government office who is holding it on the basis of urgency or need. That too tends to be allocated on the basis of family status. And then there are a number of different government benefits or tax credits which can be claimed on behalf of relatives. Oh, that's not it, of course. We just discussed rights around making medical decisions for someone else. Being a family member doesn't automatically give you the right to make financial decisions for someone else, but it does give you preferred status when getting it. It gives you a number of different advantages that make it easier. And then the right to sue, to bring a legal claim, if a family member is injured or killed by someone else's negligence. One thing that you might notice is that a lot of the powers and rights that family members have, they kind of deal with urgency, need, crisis. Something happened. We'll let a family member do X to deal with it. And that is because of an underlying assumption. Family should help. If you're in a position of need, we want family members to be able to assist you if they can. And we're going to write the law in such a way as to assist them in doing that. That has a couple of consequences. It means that there is this secret social safety net that is woven throughout the law that is based on the assumption that there will be family members to assist you. There is not the same kind of safety net that is built to assist supportive friends or community members who you have around you. Also, a lot of these provisions, it's hard to know in advance whether they're ever going to be relevant to you. We don't have to know, those of us who have stable family situations. We can have some assurance that if there is some kind of crisis, then our personal situation is going to be recognized in the law. Our family members are going to be given the legal tools that they need to try and help. That's not something that exists for people whose important, significant relationships are not legally recognized. There are a number of possible responses to this, and a bunch of them are systemic. Some of them involve trying to educate decision makers on the fact this is one way in which people who have aged out of the foster system are made more vulnerable and are excluded from some of the protections that are enjoyed by people who did not go through that system. But also, there is the option of educating young people about the rights that they do have so that they can determine for themselves how they want to exercise those rights and how they want to define their family legally. What do I mean by that? Well, here's another example. Let's say that we have another 21-year-old who aged out of society care, and now she is in university. In this case, she's in the process of reconnecting with her original mother, trying to rebuild a relationship. In that process, tragically, her original mother dies abruptly in a motor vehicle accident. So this young person is struggling to cope and to stay in school. They can't afford regular counseling. They're stressed over academics. They're stressed over their financial situation. For a hot minute, they think maybe I could inherit something from my mother's estate. And then they find out, oh no, she has a will. She left everything to her horrible second husband. This person, in fact, has more options than they know about, arising from the fact that she has not been adopted. She is still defined legally as a member of her mother's family, and that affects the rights that she has available to her. For one thing, even though she's not named as an heir in her mother's will, she might be entitled to share in her original mother's estate. So she could have a right to child support payable by the estate. As we know, the right to child support doesn't terminate at age 18. Her mother died in a motor vehicle accident. Family members can sue if a family member is hurt or is killed by someone else's negligence. She could have a right to bring a legal claim against that person. She could be entitled to legal assistance paid by insurance in bringing that claim. She could access the surviving child benefit under the Canada Pension Plan, which is a benefit paid to young people between 18 and 25 if their parent has made contributions to the Canada Pension Plan and then passed away. She could potentially be eligible to $300 a month from that source. So it's not going to buy a mansion, but maybe that helps alleviate some of the financial crisis. Now I see Tennille saying, might the public guardian step in these scenarios to protect these individuals, owing to previous extended care and the fact that no kin were identified during that time period who were able to assist? Hence, an argument could be made that the latter is not in the child's best interest. Yes, the public guardian and trustee, I formerly worked as investigations counsel for the public guardian and trustee, and we did receive a number of referrals saying something along the lines of, I'm not citing any real case, but this person was removed from the care of their original parents on the basis that they were being medically neglected by their original parents, that their treatment needs were not being met, but they're aging out, and now there's a possibility that the hospital will send them back to live with their original parents because there is nowhere else for them to go. This is it's a result that tends to shock everyone when that ends up being on the table. And in great part, the lack of suitable, safe, and affordable housing options for people, especially people who have high care needs, is a huge culprit. But the public guardian and trustee certainly encourages people who are serving young people with cognitive impairments who are coming up to the age of 18. Consider that aspect. Consider what needs to be done around that issue. Public guardianship by the public guardian and trustee. It is what it is. For some people prefer that option to other alternatives, but for many people it would not be their preference. And advanced planning can help to avoid a situation where someone invokes the help of the public guardian and trustee because there's an emergency and no one else is willing to assist. So let's say that you are assisting someone who has an issue around healthcare decision making or questions around legal rights that arise from their family status. Where can they go? Well, they can come to us if they qualify. So Downtown Legal Services, I've said eligible Toronto residents. We often do at least speak with people outside Toronto and do our best to give you an appropriate referral. My division, the Disability Health and Income Security Division, we advise around decision-making, health law, sources of government benefits, future planning. The big limitation is that people must be low income. So anyone on Ontario Works or ODSP will automatically be eligible. Otherwise, we're going to need to look at your family size and your total income. Generally, that means for a single person, income below around 22,000. But of course, we do our best to make appropriate referrals if we are unable to assist. And in terms of how to get services, we have a website with a form people can fill out, but we welcome from service providers warm referrals of appropriate cases where you know that there's an issue there that someone needs to look at. So, yeah.
So we're going to be presenting this to lived experts on May 20th and May 24th. We will be speaking to lived experts about these issues, and they may come to you with questions and requests for support. So you can refer them to Downtown Legal Services for legal support or Never Too Late for moral support. So here are some suggestions when supporting lived experts. Please only pass along advice if you are sure, otherwise refer them onwards. Connect with legal support as soon as possible and help them identify a trusted adult in their life who could play a decision-making role. Encourage honest conversations with people they trust about their wishes and values around medical treatment before a crisis arises.
One reason that we are bringing this forward to you is that as we work on this project around looking into what forms part of the family backpack and what might be useful for lived experts to hear about or to be assisted with. We're hoping for feedback from you. We're hoping for feedback about whether the people that you serve or support have encountered any of these issues, whether this information would be useful to them or valuable to them. So when you give feedback on this presentation today, or when you're making comments, we would really benefit from this information, as well as thoughts on whether there are other legal barriers arising from family status that your clients have encountered, so that we can try to be of use. So I think that we are throwing it open to questions at this point. And Aviva has just asked that would anyone on Ready, Set, Go be eligible for DLS even with income over 22K? Aviva, are you thinking that their sole source of income would be Ready, Set, Go?
Yeah. Yes.
Yeah, then I would make it happen rationally.
Thank you.
Hello, Kashala.
Hi, thanks. I have a couple of questions. So, in a scenario where someone's been adopted and they become estranged from their adoptive family and end up not coming back into care, but receiving services from a CAS through VISA and then later RSG.
Mhm.
Am I correct in thinking that the adoptive family, even though there's no relationship anymore, that they would still be the decision makers?
That is an excellent question, and you're absolutely right. What adoption does is that it just takes a big black marker and rewrites a person's whole family tree. It is permanent. It can only be changed by another adoption order in the future. So anything, any powers, any rights, any benefits that otherwise would have belonged to the original family, that rests with the adoptive family. And importantly, it's not just the adoptive parents, it's also the adoptive siblings, grandparents, cousins, the whole thing. So let's say that someone is now over 18. CAS doesn't have any decision-making power. They're estranged from their adoptive parents. Yes, their adoptive parents could potentially have the right to make a healthcare decision. So could their adoptive grandparent or uncle or cousin.
So, a somewhat connected question then is, if a young person in that scenario does designate someone of their choice to make decisions, could that be overridden by someone who is considered to be a legal family member?
Let me go back to the priority ladder. So the way that the priority ladder works, yeah, where did it go? Where did it go? Yeah. So the way that the priority ladder works is that the highest person on the ladder who is available and willing to make the decision is going to have the power to make it. And if there's no one on a certain rung who is available and willing to make the decision, it goes to the next rung down and we see whether there's anyone who's there. So if someone has made a power of attorney for personal care, appointing a person that they choose, that person is right up there at the top of the ladder. No family member, adoptive or otherwise, is going to be higher than them. The problem that can come up is if their attorney for personal care is not available, or if they, for example, pass away and they don't appoint someone else, then the rest of the ladder still exists. So the hospital would keep having to move down to find someone who is available and willing. This is one of the big problems with the fact that, as I said, a person can't say, oh, and by the way, do not let Bruce make a decision under any circumstances. I think that we would really like someone to be able to exclude someone from the ladder completely, which at the moment the Healthcare Consent Act does not allow for. The only thing that you can do is to put a lot of people above that person on the priority ladder. So if someone says, I absolutely do not want Bruce to make decisions under any circumstances, then what I would say is, okay, well, when we make your attorney, your power of attorney for personal care, let's have a few options there. Let's have someone else who can make decisions if your primary attorney isn't available anymore. I'm looking for hands. I'm looking for hands.
We have a couple in the chat as well.
Oh, yeah. Yes. Okay. So if CAS makes an application to the Office of the Public Guardian and Trustee prior to a young person's 18th birthday, if the client is nonverbal and has a severe developmental disability, does this have to go to court in order to have the right to appoint a substitute decision maker or have a public guardian appointed in the absence of a family member who would be trusted to make a decision in the young person's life? Thanks so much, Kimberly. Does it have to go to court? That depends on the kind of decisions that need to be made. Basically, we recognize two main categories of decision: property and personal care. For property, there are a couple of ways to have the public guardian and trustee appointed as guardian for property that do not involve going to court. For personal care, the only way to appoint a guardian of personal care is to go to court. The only way to have the public guardian and trustee appointed to exclude everybody else on the priority ladder is to go to court. I've been involved in a couple of cases where the public guardian agreed to accept an appointment as attorney for personal care. Those are very, very rare. Sheila asks, where would a guardian come from? Who is the consent and capacity board, and why would they appoint a decision maker? A guardian can be anyone. Any responsible person can act as guardian. So a former foster parent could be appointed as guardian of either property or personal care, but it doesn't have to be a former foster parent. It can be anyone who is willing to fulfill the responsibility. Obviously, you hope that it's only going to be a person who can be trusted. But that is one way that it's one option for planning. If someone is already exhibiting cognitive impairment, that means that they cannot make decisions for themselves, then applying for guardianship is one way to secure that. Who is the consent and capacity board, and why would they appoint a decision maker? So that's a great question. As you see, this option is just kind of hanging out in between the family decision makers and a guardian or attorney. The consent and capacity board is a board, a special kind of mini court that has the power to do a number of things that relate to decision making in a healthcare setting. Without getting into any of that, one of the things that they can do is to hear and decide applications from someone who wants to make maybe a specific decision or maybe a series of related treatment decisions on behalf of someone. So the application process looks like filling in several forms and submitting them to a body who will review them and hold a hearing on them. Consent and capacity board can't appoint a representative over the objections of the person concerned. And the consent and capacity board generally does not appoint someone to make all medical decisions for everyone in every way forever and ever, but it is an option that is available for someone who wants to be appointed in a fairly expeditious way to make specifically decisions around medical treatment. And that is available to friends, former foster parents, non-relatives who are willing and ready to make a treatment decision. Is it true that the referral to the public guardian and trustee can only be made when youth turn 18 and not before? So a guardian of property can only be appointed for someone who has turned 18. A guardian of personal care can only be appointed for someone who is 16 or older. So that means that if it's anticipated that there's going to be an issue with personal care decision-making, medical decision-making for someone between 16 and 18, there can absolutely be a referral to the PGT. And in addition, you can speak to the PGT, talk to the investigations unit about an 18th birthday that is coming, that is on the horizon. In some situations, PGT, when I was at counsel there, dealt with people saying, we know this is going to be an issue. We know that as soon as this person is 18, their father, their original father, is going to be looking to take them home for their medical benefits, but we can't start a guardianship proceeding until this person turns 18, say. And we'd say, well, first off, yes, you can, because they've already turned 16, so a guardian of personal care can be appointed. But even for a form of guardianship that can only be granted when the person turns 18, you could bring the application beforehand and just not ask for an order until they cross the 18 threshold.
I think that's it for now. I'm sure there's more questions that people can probably follow up with. I really appreciate Philippa and Charlene, both of you, for presenting today and providing all this information. As you mentioned, you don't really think about it until it comes up, and so it's great information to share for people to be educated about and understand. I just want to let everyone know in the chat there is a feedback form if you have some time to be able to give that back for the presentation. But also we'll be
really appreciate it.
And then we will be following up with the slides from today. We'll also include that link for the feedback, any other resources that come up. But we really appreciate everyone meeting with us today and learning some information from Downtown Legal Services and Never Too Late. I hope everyone has an incredible rest of your day.
Thank you so much, everyone. Take care.